Good afternoon, everybody, and welcome to the first in our Brodies Spring series of webinars dedicated to social and affordable housing. My name's Tony Convery, as you'll see on the screen. I'm a senior solicitor here at Brodies, and I form part of our social housing practice. This is the first of 3 webinars, and I'll come on to mention a bit more of what's coming up in the webinar series later. But in general, I suppose we're hoping that the series will provide an insight into some contemporary legal and commercial challenges and issues on the horizon for social and affordable housing providers. And for those purposes, we'll be covering a wide range of topics which we've assessed as relevant to the sector and the kind of things that we're dealing with day in and day out here at Brodies. Our first topic today, as you'll know because you've signed up for it, is the rather grandly named Social Housing Management Recovering from COVID-19. And really I want to kind of break that down into 3 elements. So the first is to just kind of familiarise ourselves with where the social housing sector is at in the current climate after 2 years of responding to the pandemic. I then want to cover what is the most recent significant legislative change, which is the reversion to the notice periods that were in place prior to the pandemic, which is quite a significant departure from those that we had in place during the pandemic. And then I want to talk about some of the anticipated challenges, not so much for the sector as a whole, but particularly in relation to managing housing stock and recoveries. So if we move on to the next slide, as you'll see, what I'm hoping to do here is to reflect a bit on the social housing environment. And if we move on, we'll see, that's the slide, thank you very much. I want to cover where we are now. And I think really it's a good picture, it's a healthy picture, but there's some points of note that we can see in recent statistics. The latest statistics that I think are available from the Scottish Housing Regulator show that aggregate rent arrears have risen to 6.53% of rent due, which is the highest level that the SHR had measured since they started collecting these statistics at the start of the pandemic. The number of vacant properties is also high. The most recent statistics, I think, are from December 2021. And there were 10,089 vacant properties, and that was the first time too that the number of vacant properties has passed 10,000 since the beginning of the pandemic. There were fewer applications relating to homelessness in the most recent reporting round from the SHR, and there was a slight reduction in the number of households in temporary accommodation. In terms of the financial position of the sector, recent SHR work shows that lender investment in RSLs remains high, that liquidity remains robust, and the RSLs have continued to raise significant levels of private finance on the markets. Cash balances and surpluses in the sector as a whole are also in a relatively healthy place. Although it goes without saying that looking at the sector as a whole means that some RSLs will be performing better than others. But overall, a healthy and resilient performance for RSLs over the course of the pandemic. So that's where we are, but what is on the horizon? Well, that's what we're talking about on the next slide, please. Well, we see some challenges on the horizon, and my colleague Fiona McLeod, who's presenting next in this series, will be talking about broader challenges for the sector. What I'm keen to talk about in particular is the challenges as it relates to housing management. So I think the first key challenge we see is anticipated pressure on RSL finances. This might include pressure caused by, for example, delayed investments over the course of the pandemic. It might be contributed to by the recent and significant problems in terms of supply chains and costs for both material and labour. And the impact of this on RSL finances potentially can manifest itself, as you'll be aware, in the rent costs that are being set for tenants. And I think we're going to see a challenge there and a tension there in the months to come in terms of RSLs satisfying themselves of their financial health, but doing so in a way that doesn't place undue pressure on tenants. And that brings me on to the next point, which is anticipated pressure on tenant finances, because we all know that it's not only social landlords feeling the squeeze, and we all know that tenants too will be feeling the squeeze at this point in time. I think that's particularly the case where some of the support that might have been available over the course of the pandemic is either coming to an end or has already come to an end. So furloughs no longer available, that the tenant grant fund has closed. And so these are challenges that tenants are having to adapt to in a difficult environment. That is going to be on top of the rising price of utilities. And it means that tenants are going to find themselves with higher costs than previously. The impact of this, I think, is inevitably going to find itself in the level of rent arrears that registered social landlords and social landlords as a whole are seeing. Connected with that is the residual COVID effects on tenants. And what I'm talking about there is, for example, people that have lost their jobs over the course of the pandemic, people who are suffering from long COVID, and I'll come on to talk about a bit about that later on. And that too has the same kind of impacts as we discussed before in relation to tenants' financial health as a whole, and the likely impact on rent arrears and management of housing stock. The other challenge we see on the horizon, and it's a challenge that social landlords, local authorities are already facing, is the continued challenges of compliance with the unsuitable accommodation order. So as you'll be aware, the unsuitable accommodation order was extended to all households during the pandemic, and COVID-related exemptions from the unsuitable accommodation order have now ended. And local authorities, I think in the statistics that are available, are really working hard, but are sometimes finding it very challenging to comply with the unsuitable accommodation order. And that is likely to continue in the months to come. And you see I've got an others bullet point there, and that's really because one of the purposes of these webinars is to have something of a discussion. So if you've got views on what kind of challenges are on the horizon for social housing providers, be they RSLs or local authorities, then that's something that we'd be very interested to hear about. So if we can move on to the next slide, please. We've discussed where we are, we've discussed what we see on the horizon. What I want to discuss now is the changes to notice periods, and that's the key legislative change that we've seen in the social housing sector recently. So as many of you will be aware, at the start of the pandemic, the Scottish Government increased the period for which a social landlord had to serve notice of its intention to raise proceedings for recovery of possession from 28 days to 6 months. And this, combined with certain other interventions which have since fallen away, had the effect of very significantly restricting social landlords' ability to recover property. That extension of the notice period from 28 days to 6 months was renewed several times, but came to an end at the end of March 2022. And so we now find ourselves back in the pre-COVID position in relation to notice periods. And that is that notices of proceedings have to be served on a 28-day notice period before proceedings for recovery of possession can be raised. That applies to Scottish secure tenancies, and it also applies to non-antisocial behaviour, short Scottish secure tenancies, and changes had already been in place for antisocial behaviour, short Scottish secure tenancies. An important point to note, and it's one that we've been asked a few times now, is that if you are a social landlord who's served a notice of proceedings, for example, on the 30th of March, on a 6-month notice period, it's not open to you to withdraw that notice and now serve a fresh notice on a 1-month notice period or 28-day notice period. And the Scottish Government has been very clear that that's not acceptable, and it's clear on the face of the regulations that an attempt to shorten the notice period for a notice that was served prior to the 31st of March, it will not be successful, and it's almost certainly going to lead in, if proceedings are raised on the back of that notice, those proceedings being incompetent and being defended on that basis. So for those notices that have been served prior to the 31st of March, we wouldn't suggest social landlords to be revoking those notices, but it does mean that it makes sense to have your ducks in a line for when 6-month period has passed after those notices have been served, in order that proceedings can be raised as soon as possible thereafter. So if we move on to the next slide, please, and it's continuing on the theme of recovering possession and some of the challenges we anticipate moving forward with that coming out of the pandemic. And there's a few challenges that I want to cover, and some of them are legal and some of them are more practical. And again, we're always interested to hear your views on these. The first challenge, or the first new things I think we need to think about in the context of recovering possession after the pandemic, is new arguments that are going to be raised, I suspect, about the reasonableness of eviction. Now, how successful these arguments will prove will vary from court to court, unless we have some appeals and get some more guidance on this point. But I think it's fair to say our view is that an appropriate starting point is that social landlords might find themselves needing to provide a bit more by way of explanation than prior to the pandemic as to why it is reasonable to recover possession of properties. And we think there's a few things for social landlords to consider in this context. If you're going to be going to a court and saying there are huge rent arrears here, we want to recover the property on that basis, it would be helpful if a social landlord is able to demonstrate some of the following in our view. So the first is the existence of substantial arrears prior to the pandemic. And I think this is going to be relevant because tenants who didn't have arrears or didn't have substantial arrears prior to the pandemic are likely to point, quite understandably, to the unique effect of the pandemic and to argue that this points away from recovery of possession being reasonable in the circumstances. So if a social landlord is able to answer that straight head on by saying, well, the arrears were already very significant before the pandemic, then it will be in a better position to counteract the suggestion that the pandemic is a unique event which shouldn't form the basis for recovery of possession in the particular circumstances. The second thing that a social landlord will want to think about whether it can demonstrate is the additional assistance that has been provided to a tenant in the course of the pandemic. So, for example, has the social landlord, whether it's local authority or the RSL, pointed the tenant in the direction of the tenant grant fund when that was available? Was there support being provided at a local level? And where there was support being provided at a local level in relation to maintaining tenancies during the course of the pandemic, it's worth considering them in detail, and if there's a decision to seek recovery of possession, narrating them in detail for the court. And that's particularly so if you can show, here's all the support that was offered, but either wasn't taken up or it made very little difference. Because in presenting that, a court is more likely to be persuaded that in circumstances it is reasonable to grant in order for recovery of possession. The last bullet point that I want to cover is efforts made by the tenant in respect of repayment of arrears. And this is a point that has always come up in recovery of possession. But it's perhaps one we need to confront head on in the context of COVID. If, for example, someone lost their job during the pandemic but has since regained their job or gained a different job, if they have since then not made efforts to repay their arrears in circumstances when they might reasonably be able to make efforts to repay their arrears, that will be something that social landlords want to think about when determining whether it's appropriate to seek recovery of possession, and if so, to narrate for the court when seeking to recover possession of the property. So reasonableness, an old concept, one with which social landlords will be well familiar, but some new applications and new manifestations, I think, in the context of recovery from COVID and recoveries of possession in that context. If we move on to the next slide, the next topic that I'm looking to cover is potential equalities considerations in recovery of properties. And I want to discuss this concept of long COVID. Now, you might be thinking, why is he wanting to discuss that? We're at a social housing webinar. Well, the reason that I'm looking to discuss it is because there has been some suggestion from the Equality and Human Rights Commission, which is the regulator of equalities in the UK, that at least in the employment context, long COVID might be regarded as a disability under the Equality Act 2010. And if that is the case in the employment context, it would be surprising if it wasn't the case in other contexts, including in social housing. And so if we start from the premise that someone suffering from long COVID may be suffering from a disability, social landlords will want to consider carefully the appropriateness and the reasonableness of seeking to recover possession of the property in which they are living. It's important to note that for the equalities considerations to come into play, it does not, a social landlord does not need to have concrete evidence that someone is suffering from a disability. If a social landlord considers that there's a real possibility based on evidence that someone's suffering from disability, then they need to consider the equalities implications of seeking to recover possession at a very early stage. And in that context, the public sector equality duty comes into play, which is an obligation to consider at an early stage in proceedings, so prior to making a decision to recover possession, to apply the social landlord's mind to equality considerations and to the social landlord's duties under the public sector equality duty and the Equality Act in determining whether or not it is appropriate to recover possession. Now, it's very possible that having done that, a social landlord will take the view that notwithstanding that someone has long COVID, it remains appropriate to recover possession. But unless the social landlord can demonstrate having done that work at an early stage, it may find itself in real difficulties later down the line when it's seeking to recover possession of that property in court. Having carried out that public sector equality duty consideration, and the way you do that might be in an equality impact assessment, a social landlord should be thinking about how does that inform our next steps. So if, for example, you're taking steps to comply with pre-action requirements by providing support or referring to support services, think about how can that be communicated to someone with long COVID? Is there a need to make reasonable adjustments? Is there a need to vary the way in which the landlord engages with them? Should visits be staged at a particular time or communication made in a certain way? Considering the equalities impacts at the early stage should inform this approach. And again, doing it properly and doing it early means less likely to be successfully challenged later down the line. The fact that someone has long COVID is always going to be relevant to reasonableness, and the general points that I made in the previous slides about reasonableness are all going to apply in particular to that context. And you can well see tenants who found themselves in financial difficulty as a result of long COVID, making quite compelling arguments to a court that in circumstances it's not reasonable to recover possession of their property. And that will be particularly so if there were not rent arrears prior to the pandemic. The final point to think about is that if someone has long COVID and if we accept that could be a disability for the purposes of the Equality Act, then the whole concept of disability discrimination is opened up in the context of seeking to recover possession. And the social landlord will need to satisfy itself that it's complying with the law as to disability discrimination when it's seeking to recover possession of the property. Again, that's not to say that you can't recover possession of property from someone who has long COVID, but it will be important at all stages for the landlord to apply its mind to its equalities obligations, including from an early stage, and to record its reasoning and why, notwithstanding having considered the equalities considerations, the social landlord considers it appropriate to seek to recover possession of the property. If we move on to the next slide, please. What I'm looking to talk about here really is not particularly new legal concepts or new manifestations of existing legal arguments, but really some practical considerations that we've found since basically the return to recoveries after the pandemic that make what might have been before being quite a well-honed and routine process a bit more challenging than it was before. And there's a few of these I want to cover. The first is the level of arrears that some tenants might now find themselves in. As many of you will be aware, the ordinary way for properties to be recovered in Scotland is by something known as a summary cause summons. But if you're looking to recover money as well as the property in that context, the maximum amount that can be recovered is £5,000. And we find ourselves with many clients seeing tenants that have arrears of more than £5,000. Now, if you have arrears of more than £5,000, a decision has to be taken by the social landlord. Is there a reasonable prospect of that money being recovered? But if the view is taken that there is a reasonable prospect of that money being recovered, it will necessitate seeking to recover the property by an alternative and more complicated procedure, one that will cause more expense to the social landlord and which will probably take longer. And so these unusually high level of arrears mean that challenging decisions are having to be taken at an early stage as to whether pursuing these high levels of recovery is to throw good money after bad. So that's a new challenge, I think, or one that wasn't making itself known as commonly prior to the pandemic. The second kind of practical challenge we are seeing is in sheriff court administration. And this is connected with some of the Shrievo experiences that I'll come on to in a moment. My experiences, and I'd be interested to hear what other experiences are, is that sheriff courts are a bit out of the way of processing these cases. Whereas before there would have been a regular heritable court, there might have been a clerk that normally dealt with these kind of things. That is not as often the case anymore. And so, for example, when actions are being lodged with court, it is often taking longer for those to be turned around and taking longer for dates to be fixed. And that impacts on housing management, because it means that properties that social landlords might have expected to recover by a certain date aren't recovered by that time, and that therefore people who are waiting for houses aren't getting the houses that they would otherwise have been entitled to. Connected with that is the experience not of the administration but of the sheriffs themselves. There's been a huge turnover in sheriffs since the pandemic. There are lots of new sheriffs, and even that aside, the sheriffs that have that were in place even before the pandemic will not have been doing this kind of work regularly for a large part for 2 years. And that again manifests itself in how quickly these things are progressing, how much work is needing to be done by those seeking to recover possession of properties, and how long it's taking, for example, for decisions to be given. So when we're thinking about the timeline of a case prior to the pandemic and the timeline of a case now, I think it's fair to say we're expecting these things and we're experiencing these things to take a bit longer than they did before. The timelines issue aside, I think Shrievo attitudes to recovery of possession are perhaps a bit more sceptical than they might have been before the pandemic. Now, this can only be anecdotal necessarily, but I think sheriffs are carefully scrutinising the grounds for recovery of possession, and particularly where there's a COVID element to these things, for the kind of things we've talked about before, of whether it's long COVID or people who've fallen out of work during the pandemic. Particularly in these circumstances, sheriffs are applying close and detailed scrutiny to applications to recover possession. The final point I want to make, and it goes back to the timelines point, is backlogs. And I want to talk about backlogs both within social landlords and also in the courts. For social landlords, because recoveries were paused for so long, there might be many tenants on the books who might otherwise have faced questions as to whether it was reasonable for them to remain in that tenancy, who have maintained their tenancy meantime. This is now the time where we're seeing social landlords having to work backwards, really look at those cases and say, we didn't take action during the pandemic either because we chose not to or because we weren't able to because of the rules at the time, and having to make a decision whether now to progress actions for recovery of possession. And that is finding its way into the courts as well. So whereas prior to the pandemic there would have been a steady stream of these cases, there's now something of a bottleneck, and there's lots of these cases being lodged, including cases that are being lodged just to be dismissed because they've been sitting there for so long. But that means that there is a bit of a bottleneck, and connected with all the other reasons I've talked about for a delay, that's causing delay in how these proceedings are progressed. So that is brings to an end, I think, what I'm looking to say about recovery of possession and about the challenges we see for housing management generally. So I'm now going to open the floor to questions. I think, yeah, so we've had a couple when I've been speaking. So the first, I think, and it's kind of picking up from where I've just finished actually, about is the experience of recovery different from prior to the pandemic when you're in court? I think, and it's really kind of rehearsing something of what I've said already, the experience is different. It's practically different because an awful lot of this stuff is still being done virtually. An awful lot of it is still being done on papers. But it's also different for the reason that I kind of mentioned before. I think sheriffs are very carefully considering recoveries for possession. That might be because they're the way of doing this kind of work. It might be because they've never done this work before. But I think it's also contributed to by a kind of attitudinal change, particularly in connection with people whose arrears have arisen substantially in the context of the pandemic. And I think that's something that social landlords need to think about when determining whether it's appropriate to recover possession, and also those acting for and advising social landlords need to think about when working out how they're going to present that kind of thing to the court. And the next question, so the next question is to do with notice periods. And it's, yeah, so it's a question to do with a notice that's been served when it was still a 6-month notice period, but which, if it was served now, would be able to be acted upon quicker, and whether there's any way that can be shortened. I'm afraid the short answer to that is no. The Scottish Government was very clear in terms of making the regulations that provided for this kind of transition from a 6-month notice period for recovering possession to a 28-day notice period, that people who had already been served notices of proceedings on a 6-month notice period had a legitimate expectation that proceedings wouldn't be raised before then. And I think the view was taken was that it would be unfair to then revoke that notice and serve a notice of proceedings on a 28-day notice period. And so I'm afraid, and I'm sorry to be unhelpful, but the answer is that there's not a way to shorten that notice period. And as I mentioned, the important thing for social landlords to be doing in respect of those cases is to be making sure they've got their ducks in a row, so to speak, so that at the point at which that notice goes live, at the point at which the social landlord becomes entitled to recover possession, it can move quickly to do that. And that's the most efficient thing that can be done in terms of recovering the housing stock as quickly as possible. And that is, I suppose, on the assumption that in the meantime, the tenant hasn't remedied their situation. And as you all appreciate, there certainly are circumstances in which a notice of proceedings concentrates the mind and means that tenants reach out, for example, for support. And clearly, if in the intervening period, the grounds for recovery of possession have shifted, and, for example, arrears are much reduced, a view should be taken as to whether it remains appropriate to progress upon that notice of proceedings and whether litigation in the circumstances is in fact necessary. So that is all the questions I have just now. If there's no more questions in the Q&A function, please feel free to follow up with me after this session. My contact details will be on the next slide. So thank you for attending this session. There are, as I'd mentioned, 2 more sessions coming up in this series. The first is with my colleague Fiona McLeod, who's a senior associate in our team, and she's going to be giving something of a thematic update. So moving away from the concept of housing management and dealing more broadly with some of the challenges for social landlords in 2022, also discussing some of the homelessness trends and the policy developments, and discussing more generally what's next for housing in Scotland, some of the Scottish Government suggestions and what we're expecting to see in the coming years. So that's our May session on the 19th of May. And then on the 16th of June, my colleague Jenna Monteith will be discussing private investor delivery for social housing rent. And that will include discussing, for example, how affordable housing could be delivered in partnership between affordable housing providers in the private sector, and discussing the benefits of this approach, but also some of the challenges and potential mitigations to those challenges. And with that, it really brings me to an end of what we're looking to say today. Can I thank you very much for your attendance today, and thank those who contributed some questions. It is always good to have questions on these sessions. We are looking forward to a time at which we can do them again in person and have a bit more of those interactions. But in the meantime, my contact details are on the slide. Please do feel free to get in contact with me if there's anything you'd like to discuss. Finally, after I have completed what I'm going to say, which will be very shortly, you'll be pleased to know, there will be a follow-up questionnaire that pops up on your screen. And we are always genuinely very keen to hear feedback on these kind of presentations, to know if what we've done well, but also how we can improve them to make them more useful for you and for your organisations. And so we'd very much welcome you providing that feedback to us. And with that, all I can say is thank you very much for your attention, and have a good afternoon.